In that case, it being 7 o'clock, I will call this meeting of the Zoning Board of Appeals to order. Happy Cinco de Mayo. Our first item is working through the administrative items, would be the minutes of April 7th. So let's take a look at those. You should have in front of you a red line version, which I believe incorporates Andy Demore's edits that were previously sent to Michael. Otherwise, just ask if anyone has any additional edits or comments for page 1.
Just a quick one under the first sentence under minutes. It says the board agreed with his comments, probably should be their comments.
So there's 2 people. Those guys.
Yeah, go ahead. Any edits, comments, or questions for page 2? In the second to last paragraph, page 2, says David Randall said that the board received a request for variance. Would be a request for a variance.
It's one of those weird.
Yeah. Okay. So that, yeah. Never mind. Yeah.
But I can make it capital so that it means a very specific thing.
Yeah, they have to make every other reference to variance capital. So yeah, I'm fine with it. So I get it. It's one of those, like, grammatically it seems weird, but at the same time, you know. Any questions or comments on page 3?
Oh, I'm sorry, on page 2, just a short clarification. On the very bottom paragraph, Edward Snyder, he said that they're, where is it? Is seeking a 6x6 variance to allow for construction. Where am I? There are extensive wetlands. He said that there are extensive wetlands of the property. Wouldn't that be off the property?
On the property.
On the property.
Okay.
Yeah. All right.
Extensive. Page 3, third paragraph. Crosby spelled wrong. So just for 1, 2, 3, 4. Just so at a certain point you start capitalizing variance. So just gotta pick one of them. Okay. Pick a lane. I think it should be capitalized. In the paragraph on the middle of the page, it starts with Attorney Dowdy is talking about where the pool deck should be. The last sentence says she stated that the building commission is it it's commissioner. Any questions or comments on for page 4?
In the top there, do you want to capitalize the variance in the first bullet?
It says discussion review of section 929. Paragraph above that, my name is Mr. G. Health. G. Any comments or questions? Page 5. By the way, Mike, I'd like to ask, you have a section at the end by administrative and discussion documents. Is that the new style?
Yes, we need to have a record of every document that we look at in the minutes.
In the minutes.
In the minutes. So I just separated out ones that were discussion and administrative based, and then the ones that were related to the public hearing, because I stored those separately.
Okay. Is that a public record requirement? Or a open meeting requirement? Open.
And we'll accept the minutes of April 7th as modified. Second.
We have a motion, we have a second. Any discussion? Hearing none, all in favor?
Aye.
The motion is approved 5-0. All right. In terms of other administrative items, we have I'll just identify, we have a few pieces of correspondence. One involving the public hearing that we have coming up from the building commissioner, so I'm going to just put that aside for the moment. We have another referencing 56 Harbor Road, which is also subject to a discussion. Because we only have a few minutes, I think we should wait on that until after the public hearing at 7:15. There were 3 other pieces of correspondence from Jay Wheeler concerning some construction going on at Stow Acres, as query regarding regarding a few matters, but generally requesting per the title, copies of certain documents, and then a reference to the DEP waterway regulation program at 25 Point Road. I don't know if there's anything for us to discuss, but in case anyone has a comment or question, I'll just open the floor for just a moment. Okay.
2 more pieces of correspondence came in.
Sorry.
And they were printed out.
I'm sorry, I didn't
They were related to 56.
review my file, yes. Yes, we have 2 more pieces of correspondence, one from Sarah Klein that was received today, and one from the permit holder, the property owner at 56. Oh, actually, no, I'm sorry. Hold on. I'm sorry. My apologies. I'm sorry, from Trish Crocker. Both of which concern the 56 Harvard Road matter. Again, we're just going to put those aside, and I'll give people a few minutes to review, but we're just going to put those aside for the moment, as those are subject for discussion later on. We have just as a reminder, two important dates for the board to make note of is in 5 days, we have the annual town meeting. Elections are also on April 10th. Elections are on May 17th. I encourage everyone to participate. Otherwise, we've got 3 minutes until the next hearing, the continuation of our next hearing. So unless anyone has a matter that they can resolve in the next 2 minutes, I think we can just sit tight and look at the materials before we get started.
One quick thing.
Sure.
I am anticipating a permit application being filed by the end of this week.
For the June 2nd.
Should I schedule it for June 2nd if it comes in by Thursday?
Yeah, as of today, do we have any applications or any hearings scheduled for June 2nd? No. Yeah, I would go ahead.
Okay.
And do that.
What is it, do you know?
It is 63 Kingland Road.
Yeah, we're in neck of the woods. Yeah, no, not anymore, sold the property.
Too bad, you could have been, we'll have to recuse yourself. But yeah, whatever slot we have, we can take that. All right, so sit tight for just a couple minutes and we'll get started.
Still have time to do the margaritas for Cinco de Mayo.
What'd you say?
The margaritas gonna come in now, aren't they?
So, hey, I made tacos for my kids before I left, so, those are waiting for me when I get home.
Michael, you off 2 full-size pens?
All right, it being 7:15, we can continue the public hearing for the request for variance at 126 Kingland Road. To start things off, well, actually, the applicant is here this evening. So before I was going to go on to my other things, I'll open things with any additional information that you'd like to reference, anything that you can provide to us, or any other topics that you've pondered during the month since our last hearing that you want to discuss.
So we did, as we discussed with a few members on the site visit, we did shift the pool 7 feet further down away from the side lot line to try to maximize our distance away. So we did gain just about a foot off. So we're now in that 19 4 feet. So it's just with the angle of that property line, we weren't gaining a whole lot, but we did try our best to try to maximize that as best we could. We did indicate the equipment on the plan as well, showing that meeting the setback requirements. I think the members were able to get a look at the site, the topography of the wetland and whatnot.
Great, thank you. Speaking of which, as I think potentially the sole member who was unfortunately not able because of scheduling conflict to make the site visit, did anyone of the members want to talk a little bit about the site visit, what they saw, concerns, questions, issues that came up during their observations?
Pretty tight space, but other than that, we got to see what we needed. I did anyway. Yeah.
Good distance from that. There's a hill basically between the house and the abutting house. Moving it away, it's all wetlands back there. It's never going to be developed. I have no problem with it at all. I like it being moved. I don't like to give a lot of variances to things, so.
There
But
was,
they do need it.
there was more privacy than I anticipated for the space, so that was nice between the neighbor.
Yeah.
So just to see where the hill was.
If their kid doesn't tear down the hill first.
True. Looks like he was building on it, not the direction.
And actually, I drove by the property today just because I wasn't able to. What's interesting is actually it's pretty hard to actually see even into the backyard from any spot of the road. Hopefully no one thought I was a little odd as I was driving very slowly by the house trying to peer around. And so if you face the house on the right side, does it initially slope down? Is that right? Into the wetland?
It does.
Yeah.
Okay. That's what I was trying to see, because it looked like it almost like fell off.
It does.
back.
Yeah, it drops off
The
pretty
grade
quick.
drops pretty quick.
Yeah, okay. Okay. One thing that I wanted to just talk about real briefly, largely because it concerns this application, but all future ones, was the email that we received, piece of correspondence we received from the building commission on April 9th about whether or not the deck around the pool should be subject to the zoning setback as opposed to just the pool
The
structure itself.
Right.
And so that was obviously based on a comment that you had raised in the last meeting. Unless anyone disagrees, though, I guess I would open up. Is anyone aware of there anything like formal that actually dictates that particular rule in terms of like the zoning rule, mass law, anything that references sort of the deck area around a pool?
Each building inspector has their own interpretation.
Yeah.
Simple as that.
Okay. So I guess I just wanted to just kind of open it up for discussion real briefly as to sort of what we should, I mean, ultimately it's not doesn't make or break this particular application, because whether you measure it from the edge of the pool or whether you measure it from the deck, the variance still is required. It really just comes down to what the measure of the variance should be. But I guess I wanted to open it up to the board to at least make some indication as to, what our position is in light of the fact that we have an opinion from the building commissioner, but ultimately we can sort of render our own opinion, however that may be. And I think, at least for our purposes, it will also provide guidance to anyone in the future too, as to, what it should do. So I'll just open it up.
The only thing that really bothers me, when you give a variance, that's permanent. That changes the setback for that property.
Yeah.
And if in the future they want to tear up the pool and put a house there, they can go right up to that variance line.
Right. Yeah.
So that's always bothered me. So.
Right. My only response to that is that if these guys happen to be asking for a special permit, for example, like the rules should be the same no matter what it should be, but your point's well taken.
See, the other, I mean, if we're going to, say it's okay to do a variance for the pool deck, does that also mean that a regular house deck also can go up to the property line, or? So if we make a decision here, we're affecting other decisions we've made in the past where we've enforced zoning, or at least
I think
considered that.
the building commissioner is going to say if it's attached to the house, then it has to meet the setbacks. If it's not.
Okay.
Right. I mean, I think that I look at, for what it's worth, I wouldn't necessarily equate a deck attached to a house as the same as a deck attached to a pool, because it is attached to the house itself.
Yeah. All right.
And so, I mean, one thing I just wanted to ask is, theoretically, you could put the pool in and not put in the deck.
Good.
To a certain degree, yes.
Yeah, I'm not saying that you, an owner would like
It
it.
needs at least, in this instance, and in most in-ground pool instances, it does need some type of surround just to prevent, the washing away of the soil,
Okay.
So,
minimum, let's say 2 to 3 feet.
so, and I'm trying to think about the building commissioner's position here. So is it from a permanent point, or is it just the presence of the extension? That, because if we think a deck, that's, could be semi-permanent to a house. It's no different than this decking. It's semi-permanent to the edge of the pool. What's the difference? If the deck on a house just is considered and the decking on a pool isn't, how do you arbitrate that?
Would the variance not be specific to just the pool or?
No, it's the setback you're talking about here, right?
What's odd is that if you look under, it's the definition of, building
Permanent structure, perhaps.
or
right?
is it building structure?
I think
Structure.
that's-
It talks about, anything that's basically put into the ground.
Mhm.
It specifically says pools,
Does it?
but that's all it says.
Right.
What's also very odd is it also says driveways.
There are many towns that do have written right in for patios, and that they do have to meet the,
Yeah.
setbacks.
Yeah.
And so, if the board were leaning this way, I would be comfortable distinguishing between the deck on a pool versus the deck on a house, because you could say, well, one's attached to the permanent structure as opposed to, a pool. That being said, I don't hear of anyone digging either pool up and throwing it away.
Well, yeah, effectively a pool, you can't take it out. So it's pseudo permanent, right?
Yeah.
I would think
It's
so.
a shell, you can pull it
Same as
out.
a house though, too, I guess.
Wow.
To a certain degree.
I would think it might be like a driveway.
But
The question is like, do you equate it to like a deck to a house, or do you equate it to like a walkway in your backyard?
Right.
Which some people have, which I think would not count, obviously.
The only thing I can think of it bothering would be like conservation for like water runoff, which is nothing here, or it not being permeable.
Yeah, but it's going into wetlands, being infiltrated there, so you're not losing the water.
Right.
that would run into maybe like a square footage type, situation, and how much area there is.
We get the nice hills, we don't worry about that.
So if the building commissioner thinks it's appropriate, he probably would say that regardless of what the application is. So just go with what he has to say. I don't know that we need to really put a finer point on this.
Okay.
Yeah, that's my,
So I guess the question is, in cases like this, are we then permitting to the edge of the pool, or permitting the entire structure, so that, as Bernie was saying, where we're allowing the next owner to extend his house to?
Edge of the pool.
it's the pool edge,
Yeah.
according to the building commissioner.
Yeah, the edge of the pool.
Yeah, okay,
He's the one in the town that's charged with interpreting the bylaw and the mass general law, not us, so
Yeah. and I just want to make sure that,
it changes with.
when we're doing these variances, we know how close we're getting to the neighbors.
We'll just question each one.
Yeah, well,
Yeah,
that's
that's
really
true,
what
too.
ends up happening,
Yeah,
right?
exactly.
Yeah.
Yeah.
Which should be the process anyway.
So, I guess I don't know if we need to do it by formal vote, but I guess just like, I'll put it to an informal vote. Are we all in agreement to accept sort of the building commissioner's interpretation?
Yes.
Okay, all right, good. All right, any other, going back to the application at hand, any other sort of questions, comments, at least for the applicant, at the moment, additional information that we're looking for?
So, I'd like to get a better feel for what the hardship is on this thing. And I can see at least two of the three of the, points that they need to meet as being well met. And if this is a special permit, I probably wouldn't have too much problem with this, but again, hardship is always the stumbling block here, and I'm not sure how hardship is met. So if if you can help me understand what the hardship is for to justify a variance.
I think the two main points, would be the proximity to the wetlands as well as the slope of the yard, which again relates towards the wetlands as well, the conservation area.
Yeah. I guess as I'm looking at that, I see that being more the first condition, which is, the shape of the land, which is, point number one.
Sure.
Point number three, which is no substantial detriment to the public good, or, obviously no one's
It's
complaining. So
unbuildable,
neighbors are fine with it, when it comes to hardship, it says financial or otherwise. Some of the examples I was looking at, just trying to figure this out, and basically, one point that was made was, will it ruin the value of the property not to have a pool? Is there, and please, the rest of the, board, if there's something you can add to this so I can understand this, but basically, I'm not saying that, not having a pool will destroy the value of the house. I'm not hearing a hardship as defined by the law. And unfortunately for variances, we're supposed to be satisfied all three of that.
Financial hardship in the value of the home or towards the resident?
Well,
Obviously there would be the cost of moving it to perhaps try to encroach further into the wetland would require excessive retaining walls, which would become cost prohibitive.
Yeah, one example I have is, it's like a comment from a legal firm saying, the interpretation, generally needs to show that it's, no longer economically feasible to make a reasonable use of their property. Or existing building in place. Now that's in terms of building a larger house, but basically they're looking at, does it somehow damage the value of the property
By not allowing
this, or is there some sort of other hardship that affects the value of something? And again, am I interpreting that correctly in your opinion in terms of hardship?
I think hardship, not to say it's a bit of an amorphous term in terms of the different things. I had always interpreted it as saying, if you don't allow for the variance, it's gonna cost me $10 million more to do what you're asking me to do. And so like in this case, it was if you shift it into into this otherwise potentially unbuildable area, one, it's gonna cost, besides the retaining walls or whatever you're going to need in terms of the wetlands just for the water issue. The fact is that you do not have flat land. I don't even know how much earth would have to get moved in order to like build around that. And so, I had always sort of interpreted in part by saying, if you don't grant me the variance to do what I want to do in my spot, I can do what I want to do, but it's going to cost me, X amount of money more, to put it someplace else. Because otherwise you're right. This is not a situation where it's like, I need a variance to put in a bathroom, because otherwise, like, I have no plumbing facilities, or I literally can't build a house, if you don't give this to me. Obviously a pool is a luxury. Frankly, in Massachusetts, there's arguments that pools actually bring down the value of the house rather than bring it up, depending on how you interpret it. And so, but I've never thought that hardship has to be that narrowly defined, but I open it up to others to discuss.
Yeah, and that's what I was doing, trying to do some research to figure it out, because, I say I was 2/3 of the way there. And I'm not saying that I'm not going to be there. I just want to have this conversation.
No, of course.
The example where it's, it economically damages the value of the property, obviously is very clear. And obviously there's probably other examples that I just didn't uncover.
Yeah.
That would also meet the same criteria.
It doesn't damage the value of the property to not have a swimming pool, but you could certainly argue, on the other hand, that it prevents adding to the value of the property. Because a swimming pool does add value to a property. So, I mean, it's taking a broader interpretation of value,
Right.
but there is an argument to be made there. But I think the main argument, though, is the financial hardship in having to do this, in an alternative kind of way, given the configuration of the property and what you would have to do.
And there are two other provisions. The first one we can discuss again, but I'll just read it. The desired relief may be granted without substantially detrimental to the public good. So there's no.
Right.
And that's not a problem.
Exactly.
The desired relief may be granted without nullifying or substantially derogating from the intended or purpose of the bylaw. I think it satisfies that also. Yeah. And as far as the literal enforcement of the provisions of the zoning bylaw would involve substantial hardship, financial or otherwise, to the applicant or appellant. It doesn't really define what the otherwise is.
Right. And it also doesn't really decide, it's obviously a matter of interpretation of what substantial is.
Yeah. And it's not unreasonable for people who want to put a pool in.
Right. I agree.
Especially when in the middle of there's nothing to swim in there. Right? Like Boone is there, but that's about it for the town.
Yeah.
So it might be stretching it, but it's a reasonable request.
Yeah. I say I'm open to that interpretation. I'm just trying to, I want a conversation around it because again, the law does say it has to meet all three.
Yeah. No, it's difficult.
Yeah.
It's difficult for us and it's difficult for them to justify.
Yeah.
The only, I guess, reaction, it's not special. We aren't really contorting the regulations to allow this if we agreed to allow it, right?
Right.
I mean, it meets a pretty high standard on the set of criteria that we've listed.
The other thing, this lot is really a very small lot.
It is.
Yeah.
Because all of it's wetlands.
Right, I was gonna say that, right. The lot is not small. It's the buildable area within the lot.
Yeah, that's right.
Right, and I wanna be very careful here because size is not a factor.
Correct. It's the
It's
topology.
It's the soil, the topography, soil, and also, arguably the shape. I mean, here it is a bit of an odd sort of polygon sort of shape in terms of being able to put something in. Once you look at the buildable spot,
See, the other thing he can do to satisfy is to buy a piece of land off of the neighbor.
But there's a lot of wetland in here,
Yeah,
so
I
it
know.
still has the issue
I
of
know,
how
I still
to
have
build
wetland.
that mound up so that.
But I mean, this variance here could be relieved by moving the lot line.
Sounds like a hardship to me.
Yeah,
That's a hardship.
That's a bit of hardship, right?
Yeah. That's a hardship.
It compounds the hardship.
Can't expect the neighbor to give in. He likes paying the taxes on the 3 acres he's got there.
So.
I see no reason I can't justify a variance.
Any other questions, comments, discussion, in particular, any questions or information that we'd like from the applicant?
Did we hear back from the conservation?
Yeah, they just wanted another updated plan. They're gonna, basically just have to make the formal change of the distance.
They have
But no issue.
no issue on their side?
Any questions, concerns, or comments from staff on this particular application? Sorry to get you as you walked in the door.
No.
Okay.
Nothing else.
Yeah,
Close it here.
I'll entertain a motion.
Move it, close it here.
Second?
We have a motion, we have a second to close the hearing. Any discussion? Hearing none, all in favor?
Aye.
All right, with that, the hearing for 126 Taylor is closed. At this time, we can no longer take information, whether it be from the applicant or for any members of the public. I will open the floor for any discussion and or a review of the draft decision, if I can pass that out.
Oh, we got one?
Do we have it?
Yes, sorry, the meeting was locked.
There we go. So I'm just passing out a draft decision. If you want to take a look at it, while concurrently discussing any other additional points.
Do we need to adjust some of these?
Yeah, so, sorry about that, sorry, that's maybe I'll start. Keep it up.
Yes.
You got it? You check it? Okay. So top of page 3, which I guess is the rest of finding number 6, the side yard.
19.2.
Yeah, 18.4 should be changed to 19.2.
The rear yard, wherever that is, would be.
What is the mention? On the rear yard, what did you say about the rear yard?
The rear yard is greater than
Oh,
40
oh,
feet.
oh,
So know
okay,
where it
yeah,
is.
There's a way to.
A lot will know where, right, know where it yard.
So if that's 19.2, then the variance changes to,
5.8.
I think it's
5.8.
yeah, 5.8. Can't call it, that's the one.
Was there an extra copy?
Oh, is there an extra copy?
I think so.
There's a copy.
Oh, do I have 2 copies? Oh, sorry.
Why don't you pass that on back? Yeah, sure. Thank you.
So number 9 you have highlighted, was that just to put a date in there? Michael?
It was just in case someone wanted to add another pendant.
Oh, okay, thank you.
I would add, 2 issues of variance are being addressed, the topography and the public issue, but I would address the third one that we were discussing, which is the financial issue as well, so that it shows that it meets all 3 criteria. And it could be, what you mentioned, David, in terms of the financial cost of having to do it alternatively. Okay, and we can make that,
I think on point 11
11,
says that.
substantial, financial or otherwise, okay, yeah, I guess it would.
One small thing, do we need to indicate that there were site visits made?
Our option would be to put the pool under the house, in the basement.
Yeah,
Okay, I guess
okay,
That's expensive.
The other thing I would
a lot
say
of
is-
fun.
Okay. I would caption it maybe somewhere before you get to this with findings, because these really are findings. Maybe,
I mean, findings of the board?
yeah, something like,
No, on page 2, it says findings of the board.
Well, these are under the same heading, so,
did you say that?
so
Find out on page 4.
Yeah,
Oh, I see, okay, all right.
so did you want those to be articulated?
The
Or
findings?
well, you said there are the 3 components, or does
Yeah,
number 11 satisfy what you wanted to say?
11 does satisfy.
Okay.
Yeah,
Okay.
I guess maybe it could be articulated, these are the 3 considerations for a variance.
The only question, this is a small thing, but do we want, maybe we can use the blanket number 9 as the opportunity to indicate that, we're evaluating this based on the sort of the buildable area of the lot as opposed to the lot itself.
Well, I think that's what Lenny's kind of poking at there, right? Because that's one of the reasons why we're granting this thing.
Yeah. Yeah, so maybe if for number 9, we could say like during the public hearing, the board, I don't know,
Recognize the buildable
Yeah.
lot is substantially smaller than the
The available space.
Is substantially smaller than the total acreage or,
Yeah.
The Bill area is
Or-
substantially smaller than the 2.9 acres.
Yeah.
of the site.
Right,
severely limits the location of, the possible location of the pool.
yeah,
That does. Yeah, there you go. Good one.
the vote, the 18.4 reference will need to get changed as well.
What was that?
18.4 gets changed to 19.2, correct? Yeah.
Yes.
Suppose the date of that plan needs to be updated as well, then, right?
What's on the plan here?
What plan?
Is that the February 24th?
This is April 30th.
Yeah.
That's what the date is.
Revised, yeah.
No, I think he's already recognized it. as
Oh, you did, I'm
okay.
sorry.
Yeah. I mean, let me just, I thought he did.
I see it on conditions.
Yeah, proposed site plan dated April 30.
Okay, mine must be old.
Yeah.
Never mind.
How about the provision they have to invite us over for a swim?
Full party.
4th of July, or do you have a particular day?
That might be a touch quick pro quo. This is oh, I'm sorry.
Just a lot of technical difficulties right now.
That's okay, I don't, yeah, are you good?
Yes.
Okay, this is a very picky thing, so you can yell at me later. Number 10, where it says, the board finds that owing to circumstances relating to the soil conditions, shape, we can have it say and or topography, because or makes it sound like there's only one of those, and the reality is I think it's the shape and the topography that kicks in. So, I mean, it's a picky thing, but technically you can knock one out and still survive on the ladder. Okay. Any other questions, comments, concerns, edits based on the draft decision?
Okay, I see that. It's there. Okay.
I'll entertain a motion.
I move that we, grant the variance for, 1.6, Taylor Road for the creation, for the addition of a pool. The variance for the pool.
Second.
We have a motion, we have a second, any discussion? Hearing none, all in favor?
Aye. I move that
Motion
we,
passes.
approve the, notice and decision for 1.6 Taylor Road for a variance. Second.
We have a motion, we have a second, any discussion about the notice and decision, as amended based on what we discussed tonight? No, hearing none, all in favor?
Aye.
Motion passes 5-0. Thank you very much. With that, staff will be in touch about next steps.
Okay.
Right, thank you all. Thanks so much. Good luck. Thanks a lot. Let's moving on to our, going back to our agenda. That is the end of our public hearings. Returning to the issue of 56 Harvard Road. At our last hearing, we had discussed two requests for modifications to the special permit that had been requested by the applicant. At that time, we had determined that both modifications should be considered major modifications, thus requiring a new application, public hearing before making a decision on whether or not to grant those modifications. The applicant has since provided correspondence requesting, for lack of a better term, I guess, reconsideration of that determination on our parts. We've also received, just to note for the record, pieces of correspondence that I have previously identified that you either were provided before the meeting took place or this evening, two additional pieces. So I'll open it up to discussion amongst the board members with respect to their thoughts on the request for, to reconsider what was discussed last week. As a reminder to folks in the room or on Zoom, this is not open for public comment. So to that, I'll open the floor. And one small sort of administrative item, although it is technically not required, I think I am going to request for the board to make, for lack of a better term, a formal vote on the modification decision, just to frankly end the discussion. The last point, as a reminder, the topic of discussion is not whether the modifications should be allowed or denied, for that matter. The substance of the modifications in that regard are not relevant to tonight's discussion. It's simply whether or not it should be considered a major modification, which provides one procedural path, as opposed to a minor modification, which is another procedural path. So with that, I'm going to stop talking and open it up to the floor for folks' thoughts.
I wasn't here at the last meeting, but I've reviewed the documents and what
you can absolutely provide your commentary.
Yeah. I do think that the parking issue is a major modification issue. It does impinge on a number of different considerations, including, the abutters and just the whole configuration. I'm still not convinced on the walkway one that would be a major one. Walkways to me are kind of, they're minor from the way I would look at it. But I'd certainly be open to hearing, why the rest of the board, would feel differently.
Thank you. Thoughts?
They're asking for allowing parking on the driveway. I cannot be for that at all. We approved 26 in the horse ring, or whatever you want to call it. And I think that's what our decision is, and I wouldn't consider changing that. The other thing is handicap parking. If I believe his request for allowing handicap parking on his driveway and a parking spot in his driveway is an adequate request, we probably should have said that in the first place. And so that could be, as far as I'm concerned, a minor modification just to permit that to happen. The other thing is,
just to clarify, you're sort of breaking the parking into two pieces.
yes,
One being the handicap slot, as opposed to
General parking.
that would be more major. Okay,
parking on his driveway
would be major.
by participants should be prohibited except for the handicapped.
Okay, all right. But I'm just, I don't want to prejudge any discussions about but I'm just focusing on the major versus the minor. Okay.
The other item is the pathway. To me, the pathway has to be paved some means so that it can be plowed in the wintertime. It's not just the summer that this is being used, where grass will probably be fine, but there's wintertime, there's snow, and people, if they're using this parking lot for the horse area, they need a safe path down to the dance area, the barn. And the grass is not sufficient in the wintertime. It's slippery, icy. There needs to be something that can be plowed. shoveled or whatever. So, our conditions for the walkway, what we've said in the decision, I think is still apply. And the parking for other than the handicap still applies. And handicap parking, I would consider a minor modification to allow parking in the driveway. But any other parking cannot be permitted. Their sign, if it's not in the, where the horse paddock is, should be moved there because that's where the business is through that entrance.
Other thoughts from other board members?
I agree that the handicap parking, would be a minor matter. I think it's required, and so we should have thought about it. And certainly that's an easy change affecting no one and meeting the laws, the state law. So, I think, certainly I believe that the parking, anything beyond that is a major modification and needs discussion. The walkway, in the early discussion I said I felt could be a minor, and it's at the risk of the owner of the business to make sure that it's safe. But, I think as a group, we need to discuss it and come to a consensus that whether it's a major or minor. I mean, I can see both sides of the argument. So,
I think my opinion would be, in the letter, what I was getting was kind of saying like there's existing parking residential that goes with the house, which I think that's all right to use, but right now we don't have that defined exactly what that is understood to be. So then I think it ends up being major so that we can make sure that communication is clear.
What are your thoughts about, not to call on you. What are your thoughts on the handicap piece?
So the handicap piece, that would be, because that is required, I think in the back of my head initially, that's sort of how I was picking. It's got that 3 spots at the front there.
Right.
But then at the same time, you could be parking in such a way where you're blocking fire access and egress out. So just clarifying what those spots exactly are understood to be would be what I thought. And then the walkway, I'm not as concerned about largely from I do kind of think of it more as a farm, but that's just me. That would be more minor.
I can't remember, was there a specific number of handicap parking spots he was required to have?
We never worked that out.
Yeah.
I don't think we ever actually worked
Yeah, we
through
didn't
that.
ever describe that.
I don't think,
I just remembered, was trying to remember whether it was in any of the notes that.
One seems reasonable, but you could ask the building commissioner.
I'm not quite sure I don't know what the town laws.
Is there a ratio that should be?
It's not set by the town, it's set by the American
State.
ADA, the state. Generally, for 25 or less spaces, one needs to be ADA. For 25 to 50, I believe it's 2. And then if it's over 50, there's another formula for it.
I think we could probably stick with 1.
Yeah. So the parking in the driveway is an issue that I see in terms of if he has personal guests under a different set of circumstances and they're not there for business, then it's hard to adjudicate whether that you should have 1 or N people being able to park in your driveway because they're personal guests and it's not for business. If it's for business purposes, then I say I agree. There shouldn't be any parking allowed other than to accommodate any handicap needs or requirements. On the walkway, I don't know if I'm ambivalent, but I'm pretty concerned about the safety factor because it's a year-round operation and there's winter time and there's nighttime operations. And if it's not properly maintained or people can't egress properly, then you have some liability there. That's what I proceed. So it should be able to be maintained properly to allow that kind of conveyance to occur.
So if I can read it between the lines of what you're saying, so you're leaning towards, sort of abiding by the prior sort of board determination that those should be major modifications, subject to,
That would be my,
oh, okay. Okay.
But it could be, I understand what you're saying, you think it should be changed, but it's possible in theory it could be changed as a minor modification as opposed to a major one.
Well, the thing is, the applicant doesn't want to have to build any walkway. And we're saying our decision had been he had to build a walkway in. So, what he's asking us, to make the change to no walkway as a minor modification.
Right, but I mean, we could say that what he's requesting is a minor modification, but at the same time, we don't think it's an acceptable one because of safety issues. In other words, it could be done within the context of a request for minor modification. And I hope I'm not splitting hairs here, but I'm just saying that, it could be under the consideration of a minor modification and still be denied based on safety considerations. Just looking at procedure versus substance.
Yeah. Let me, I think, dispose of what I would consider the low hanging fruit here, which is, I'll put this to a vote. Who's in favor, and by the way, this doesn't need to be by consensus. There's no actually rule that says this has to be by vote, but I'd like to take one just so it's clear for the record, with 3 votes being subject to passage. But reading the room, I would ask how many of those are in favor of determining that the request for modification with respect to parking should be considered a major modification, as we had previously decided, with the exception of the insertion of a handicapped accessible designated spot within the driveway of the property. Is that true?
I guess I don't have a vote on this one.
No, but I'm happy to have you weigh in.
Well, I'll agree with it anyway.
Okay.
I do get a little confused on the calling it a modification if it was existing.
What do you mean by existing?
Well, like, it's running with the residential house. In my mind, like, when you buy that house, in order for the house to be there, it's got a certain amount of parking spots. So there's a certain part of me is like, oh, those spots exist,
Right.
but they weren't clarified.
I think it's more, the way I see this is that for the handicap spot, for example, because that's the only one that we'll determine that was a minor modification, is that, right now there is a requirement that any parking spaces associated with the business must be in one location. It's silent with respect to this, with what the exceptions could be. And I think for us, the determination is that it's a minor modification to indicate that there is this exception for a handicap spot.
Yeah.
that isn't necessarily adjacent to the regular parking. That's really what's happening, right? We're separating that out.
Right.
We're not requiring it to be up top.
We never thought about it.
Right.
Never thought about it.
Right, exactly. But I think it's and ultimately it doesn't really change the substance of what had been decided.
Correct.
Okay. So, all right. So with that, the request for modification for parking will require application, public hearing notice, etc. With respect to the handicap spot,
Can we do it tonight?
oh yeah. No, of course we can do it right now because we don't need a public hearing for it. But
Before you switch gears, a formal motion should be taken for each of these determinations now. So,
okay.
so if you're gonna say, with the exception of the handicap parking, moving the other parking spots to the driveway would be major.
Okay, fine.
Something
I'll entertain a motion.
Let's take the handicap first.
Right.
I would agree to, I move that we require a handicap parking place along the normal driveway and parking areas of his present residential setup
Second,
as a minor modification.
second it.
Okay, we have a motion, we have a second. All in favor?
I got a comment first.
Oh, sorry, I'm sorry. Any discussion?
Just in terms of the, handicap, I mean, should we, in the motion also require that it meets the town bylaws in terms of what the handicap parking, or whatever the state by,
Well,
signage and what have you?
well,
That's not what we're adjudicating here.
I didn't know if that would be part of the motion, that's why I asked. Yeah.
right, the motion is just to determine that it's a minor modification,
Okay.
not what the substance of that modification is. But that's a fair question.
Okay,
Okay, all right, all in favor of the motion?
Aye.
Aye, okay. I'll entertain a second motion.
I move that any consideration of changing the business parking presently in the horse ring be a major modification.
Seconded.
Okay, we have a motion, we have a second. All in favor? Oh, sorry, any discussion? Hearing none, all in favor?
Aye.
And well, also any change to what we decided in the decision about the pathway also be a major modification.
Is that the walkway you're?
The walkway,
Yeah, walkway, that's the other issue.
Yeah, the walkway from the ring to the, what would be the density of the barn?
So I think the debate, the issue is it a major modification or a minor modification without getting first, before getting into the issue of whether it should or should not be granted.
Since it's an issue with safety, it's a major modification as far as I'm concerned. We are charged with safety.
Well, hold on, we've got a motion, do I have a second?
No, did you actually, you made the motion?
Yeah.
Okay, I'll second that
Okay,
motion.
we have a motion, we have a second. Any discussion?
What are we voting on now?
So this is,
The pathway between the horse paddock down to the barn needs to be a
major,
major modification
Right.
to what we decided in the decision.
that's the motion that's put on there, as opposed to it's a minor modification.
Okay, so if I'm on the side of minor, I just don't say aye, correct?
Well, that's right, yeah.
Say no.
You could, but you probably wouldn't.
All right, so we have a motion, we have a second. All in favor?
Aye.
All opposed?
Well, opposed being minor?
Yeah.
Aye.
Or just saying maybe.
You're the deciding vote.
I don't know, I'm
Do you want to recuse yourself and I'll vote?
I can't do that.
Yeah, too late.
I'm not arguing that, or I definitely recognize the safety dynamic with it, but I'm just also thinking that taking the liability for it and the people that are coming for that kind of farm setting.
I will vote in favor of the motion. And to explain my vote, I'll explain, if the modification request was to change the nature of the walkway from what we requested to some alternative, I would consider that a minor modification. Considering that it's essentially a waiver of the requirement, saying, you asked me to do something, I'm requesting that I basically have that entirely waived. I think that raises it to a major, as opposed to going, I want to change it from asphalt to wood. You know, that I think would be minor if it was that, but because it's a waiver of the entire requirement, I think we should, we should do it. I'm not prejudging whether I would allow it or not, but I think just under the technical question of if it's major or minor, I think that puts it to major. So I'll vote in favor of the motion as well. But I'm not trying to convince anybody, but if you want to vote against it, that's fine. So,
It's reasonable reasoning. I don't agree with it, but it's reasonable.
all right. So to lock in the votes, 3 for major, 2 for not. Okay. So in that case, the motion passes. That will require an application as well. Any additional discussion on this matter at this time? Oh, well, actually, okay. With that, now we need to talk about, correct me if I'm wrong, the nature of the minor modification. for the handicap spot.
Sorry, can you rephrase that?
Sorry.
Say that again.
Well, I think now we need to discuss like the nature of the minor modification, specifically like what that modification should be. Like,
So now that that is deemed minor, we can discuss, because you're assuming that it's not of public interest, public comment is not needed.
Right.
And it's just administrative, then you can discuss your opinions regarding that. And then at the next meeting, I can come with a decision, a minor modification decision, so
Okay.
that the board can review that and vote and make it effective.
I mean, I think ultimately, you know, I'm sorry, I don't mean to kick things off myself, but I think as long as we indicate that, you know, any handicap spot is subject to, you know, whatever legal requirements, I don't know what the size would has to be, but whatever the law says it has to be, it should be that. And I think it should also be, there needs to be a sign. I think it should be, there needs to be a designated spot
Right.
for it. So some appropriate signage, you know, should be there.
It has to conform to the Americans with Disabilities Act, which is federal.
Right, yeah, whatever that requires.
And do we need to consider where it's positioned on the driveway? So, you know, if it's a handicap accessibility issue, do we need to get it closer to the building, or is that one thing that we need to consider at all?
He's got an area there for 3 cars at least.
Yeah.
And, you know, if he parks in there, is he gonna get a ticket from the police for parking?
No, that's not my point.
I
My
know.
point is, you know, if you have handicap access, well, you don't want it way over there. If the building is over here, right? You'd like to have it adjacent or in some proximity.
In his area where he has the 3 parking lanes, it can be his choice where he puts it.
Okay.
He can put it there, or he can put it down by the barn.
Yeah, no, I think that's fair. I mean, from my particular opinion would be that, you know, I'm in favor of saying you follow whatever is legally required, and otherwise it's up to your discretion as to where you put it.
Yeah.
You know, I mean, you know, if you're legally required to put it as close to the site as, you know, physically possible, you know, and that's fine. I mean, you know, having been on that driveway, I have thoughts as to kind of where I would put it, but I think it's reasonable to say, well, I don't want it. I think it gets down to a level of detail that we don't need to get to say, like, we're gonna designate the exact spot as to where it's gonna be. So I think whatever is legally required, and as long as it's on the driveway area.
That's it, I think it might help designating it exactly where it is, at least for him navigating with neighbors.
Well, that's why I want the signage.
Yes.
I think that's why, that way it's sort of publicly known, like, that is the handicap spot. So if there's a handicap car there, like, we know why it's there.
Yeah.
You know?
Okay.
I don't see where the neighbors can complain about having handicap parking. In fact, one of them wrote a letter saying they agree. it should be.
No, it's a smart idea, and I think frankly it was a mistake. I think we all agree, it was a mistake on our part to not even think about including that, and frankly, we'll probably never forget that again, if anyone has a request like that. So, all right, any other thoughts or comments for Michael's benefit to put in the draft decision that we will, that we can consider and then vote on at the next meeting?
I don't have any.
To the extent that anyone does, I mean, certainly we can talk about it at that time, or you can submit any thoughts on your own to Michael, at that time. Is there any other?
One
I'm sorry.
question, sorry,
Yes.
just thinking, just seeing these others, if the parking's coming up as a modification during that hearing, does anything else come up during that, or does it stick to just that?
It just sticks to just that, just like any other application. You know, if you submit an application for your property to do one thing and every single abutter has a problem with some other aspect, you know, saying like, oh, you know, you're gonna start building a nuclear facility on your property. Well, that may be true, but that's not the subject of it. So the scope is gonna be limited to just what the application is. And so, I mean, if the applicant chooses to put other things in there, that opens the door. But, you know, if the application is limited to only certain questions, those are the only questions that we're gonna be considering. So, okay. Any other items on that particular item? Okay. Returning to the agenda for additional items. There were 1, 2, 3, 4, 5, 6 special permits granted in 2023 as part of my lovely idea to review some past special permits. Those have been distributed, to others to take a look at, before the meeting. I believe staff had, also provided commentary, that there were none, that were,
No concern.
expressing concerns. I'm assuming the building commissioner, to your knowledge, has not indicated any concerns with any of those properties.
No.
Okay, and I think at least in one, if not more, certificates of occupancy have already been issued.
Yes.
Okay. As a side note, by the way, 42 Packard Road, which is listed, I'm actually in a butter. So for purposes of this discussion, consider myself accused from having reviewed that one. That being said, I'm not going to sit in the audience in case it comes up. But I'll just open the floor if anyone has discussion, thoughts, concerns, comments about any of these properties, any of the special permits that were included.
Just thought about the library, and I know there's a warrant item that we're looking for more money, and what happens if that doesn't get approved? Do we know what happens there with this permit? Because it's gonna obviously influence it.
I'm sure Denise will tell us.
Right now, they're looking for funding so that they don't have to dig as much into their contingency
Yeah.
for the project. If it doesn't get approved at town meeting, it's gonna come from somewhere, whether that's through town meeting or not. So
I'm gonna take a pay cut.
I'm not involved.
We will all sacrifice our pay.
Oh, really?
So
Come to the altar.
the funding for that, if it gets approved or not, does not have any impact on the permit.
Good question.
Okay, I'm good with everything else.
Any other questions or comments? Anything that caught anyone's attention, or as we did last week, at the last hearing, are there any of these that, are still in process that we'd want to put a reminder on to take a look at again, in 6 months, for example?
They're all straightforward new homes. And that's,
Oh, Randall Road.
Yeah.
That's the golf course.
well, that,
Right, that was the maintenance shed.
that just waiting for a court decision.
Right.
That one is not subject.
No. That's the driveway.
I'll drive.
Driving.
Yeah, this is just the maintenance shed, which is not.
Okay, no, that was fine.
I believe that one's done. Sorry.
That wasn't hard to do, go through this. It's a good idea, just get them out of the way and done forever.
All right, so if there are no other comments or questions or concerns, we can sort of deem these having been reviewed and having no need to go back and take a look at them.
How about 98 Pine Point Road is what, you said he's still with the Conservation Commission and,
As of the last meeting, they still were.
okay, nothing changed.
I haven't been checking their
Okay,
website, but I can make a note to see what the order of conditions would be for them.
I guess I'll just open it up. Sort of desire, or is there a need, interest, to go back to 2022?
How many, do we know how many there were in 22?
I don't know.
No, I don't either.
I think
don't
it
know.
was either 2022 or 2021 where there was about 25.
Yeah,
Really?
One of the years had a lot.
Yeah.
But I don't remember which.
We have the one where, was it Chris on Hale Road? Oh, his tents.
Oh, yeah.
That's 2022.
Yeah, we need to look at that.
Which one?
Chris, he had tents and his artwork and all
Oh,
that.
that one,
It's like a shed garage. It's like a shed garage.
Yes, that certainly would be worthy of a review.
So like if there are, if 2022 has that many, maybe we just maybe take half of them.
Yeah, same thing we did here.
That wasn't hard to go through them. though.
Yeah, if you can take a look at
Pretty quickly,
2022,
just
within
almost
like
I don't
a dozen or so from last year, then we'll just take all of them. If for some reason there's a tremendous amount, we can always split it up. I thought clarification on how to interpret this?
No.
No, we were,
The last meeting, the board decided that we'll do the annual review once the CO is there and we review it again.
yeah, then we're done.
It'll be done.
Okay, yeah, I couldn't remember where we landed on that, so thank you. Okay, so yeah, if you can take a look at 22, it'll be the same thing. If for some reason it's an inordinate amount, then we can split it in
Yeah,
half. You can use your judgment as to where the cutoff is. Frankly, I would, if there have been COs that have been issued, which I'm guessing in a lot of cases there are, the priority should be the ones that, if there's any that the CO has not been issued, I think we'd want to know that. I'd be shocked, but you never know. Because it's been 2 years, so, all right, thank you. So, all right, the last item is the review of the draft policy for special permits. Just by way of context, because I take full responsibility for this, I meant to have this updated, talk to Michael about updating it, and asked for his notes, largely because I had forgotten about what the notes were and how to update those. So if we can just take 5 minutes to look at this one more time, I take full responsibility and blame for this. I would bang out whatever changes need to be done while they're fresh in my mind rather than months later. So, and again, because it's a policy, it doesn't actually need to be, it wouldn't be actually be part of the rules. I think it would just be put on the website once it's approved.
Yeah, it'll live with the rules.
So, yeah, it'll live with the rules, but not in the rules. So. Excuse me.
The lot is not correct. You can have it divided by a street.
Isn't the definition taken straight from the rules?
It's from the zoning.
But I'm just saying, you can have a lot. We have lots that are divided by
Yeah,
streets.
I do.
So the lot definition is not correct.
So are we gonna be using a different definition in the zoning bylaw?
We go to town meeting if we can do that.
That's
Says
that's a separate
In
question.
fact, the A&R handbook permits it too. It discusses it.
That's gonna require a request of the planning board to then request the town meeting to change it. Which we could do. You know,
It's a minor change, but
what we could do is actually, to deal with that, we can maybe make a note next to the heading definitions, maybe underneath in parentheses, just saying like, as set forth in the zoning rules.
That's the only one from the
Oh, it is?
zoning. Yeah. We don't define use non-conforming lot.
Dimensional break. Oh, okay.
and the non-conforming lot, a lot that does not have a use allowed in the current bylaw, okay, I agree with that, or does not meet at least one dimensional requirement. Okay, and never mind, I didn't read it wrong, okay.
So what is a lot that does not have use? What's an example of that?
That's just what, if you have a gas station on a residential lot.
A lot that does not have a use allowed by the zoning.
It's a business district, then it can't have a residence. If it has a residence, then it's a non-conforming lot. Even though the lot meets all other dimensional requirements.
Okay, Thank you.
Now, when you say about the lot and having lots with streets that divide them, does that make it a non-conforming lot, or is that?
No, it's still a lot, it just has a street in the middle. When you look at, on the map, they'll have little arrows pointing at each lot, and it's the same
Okay.
physical lot, it's just a street.
Down by the lake, there's a lot of them.
And we also have lots with easements going through them with the street.
Okay.
You do?
I got one.
This is well, I think technically it's always mass general laws, lawful, even though it's just a chapter, I think that's got to be lawful. Yes. In the second paragraph on page 2, it says if the structure in the lot was conforming to the zoning bylaws. Are we missing something there? Like it's conforming to the zoning bylaws at one time?
At the time of its construction.
Or maybe initially.
That way through flows from there, yeah, so, but later.
I have one of those lots. I have that, a lot that meets that description. There's a lot of them in town that meet that description. So we have the word that's in the non-conforming on the policy, the word might still,
Where is this? Sorry.
it's the second bullet, where you ended that sentence, might still require a variance. So I'm just being picky here, is this may or shall kind of conversation, or is it might the correct verb, yeah?
It's a decision to be made whether it's a variance or
Yeah,
not.
okay.
Might,
Might still, may still, oh,
I
okay.
mean, I don't think that's 6 1 doesn't the other.
Yeah, okay.
Or just may,
Yeah,
how about just may require variance?
okay, sure. Do we need to, just thinking, with the new law that passed, to have like
The accessory apartment.
yes, thank you, sorry, I was gonna say the in-law suite, but that's not what I meant. I didn't know whether we need to carve out an exception where it talks about multifamily structures.
No,
That is not considered multifamily.
No, multifamily,
it's two.
it's like.
Two families in the same building as opposed to like,
Or more.
yeah, as opposed to the shed in the back that you've converted into an apartment, yeah, alright.
There's a very specific definition in the
Yeah.
general laws about it.
Like a 1.5.
If you're friendly.
Yeah, Uncle Bob.
You have room in your lot for an accessory apartment?
What?
You have room in your lot for an accessory apartment?
Actually,
Oh.
You wanna pay for the work, you know?
Oh, yeah, I'll do that. It's your land, but I'll pay for the work.
There you go. I got a big barn in the back. That barn, it's a pretty big shed.
Oh, you have a barn?
It's not a barn, it's like in between a shed and a barn,
Oh,
so,
201 square feet.
I wonder actually how many square footage is. Could be 200, maybe.
I'm confused with the wording on the might also. Wouldn't that be shall?
I think it should be
We're
may,
gonna say may,
nay.
may require.
We'd have to decide. Or Michael would decide for it, if it was. It's good to me.
Very picky. In the last part, first bullet, non-conforming should have a dash. Actually, non-conforming should either all have dashes or not have dashes. There's an inconsistency throughout. I just noticed that, I'm sorry.
The beginning is dash. So
Yeah, so just include dashes everywhere. I'm sorry. And remind me at the end, list dormer, shed, one-story garage, proportional storage structures. That's straight out of the case.
yes.
That's it.
What's a proportional storage shed structure?
Ask the Supreme Judicial Court. I said, ask the Supreme Judicial Court. That's what they said.
Oh, is really that,
That's why I asked him. I was like, that listed straight out of the decision that, where the,
And they also have an two-car garage.
proportional storage structure? That sounds like a shed to me, or a dormer, or whatever, okay. I'm not gonna debate it.
could be a barn.
It's proportional, though. Proportional to what?
It's a modular barn.
Well, it depends. If you have a 20-acre lot, maybe a barn is proportional. If you have
Yeah, I
a
suppose.
half-acre lot, something that, it's not.
It very well might be exactly what they meant.
It's
Next
scalable, right?
court case will figure that one out, I
Yeah,
guess.
right.
That's exactly right. Yeah.
Didn't it also include the two-car garage? You can increase it from a 1 to a 2-car garage in the
Yes.
decision.
Yes, do you want all of the examples provided in here? Cause these aren't in the order from, these are just the common ones. I can-
You want to reference these court
I
cases?
mean, I can't remember how long the list is.
It's not long, it's just very wordy.
When they
Like
list, when they list the examples.
It's like 6 things, but 100 words.
How about putting a statement there, case such and such may
No,
provide further clarification?
just afterwards, just parentheses, C, case name.
Yeah,
They can look it up.
fine, yeah.
Yeah. That's fine. That's fine.
I think for that where I highlighted, even though they may in fact increase in nonconformity. I couldn't quite tell what we said last time, but there was something about that where it was small scale changes may introduce a nonconformity, but they don't increase the intensity
Right.
of the nonconformity.
Oh.
And I think that's what this is trying to say.
Mhm.
I like that wording.
Increase the intensity.
Yeah, like adding
Yeah.
that on the,
Yeah, I agree. Increase the intensity of the non-conformity. Of the pre-existing non-conformity.
You're variances still bother me, because you give a variance. You give a variance along this line, it's for the whole line. To me, it should be restricted to the area where you're providing the variance, just for that one structure, but anything else beyond that, it shouldn't apply. That's not the way it's worded, I don't think. You know what I mean?
No,
It's just like the pool, we gave a variance.
Yep.
But it should only apply to the pool itself, it shouldn't apply to anything else that's beyond the pool. Or you get a variance along this line because the house is gonna be 20 feet from this property line instead of 25. I don't like the idea that the 20 feet applies to that whole property line.
It's only the section that.
On the section that you, yeah, it always bothers me though.
I just think that's the way it is.
Yeah.
Does it really affect the whole line?
Yeah,
yeah, it does.
Wow.
and it may affect all the lines around the entire property because it's not clear.
Well, it's that dimension, you know, it's not, so if it's on the back side of the lot, it doesn't really
Well,
come across to the front.
if you give the variance on this side, does it apply to the other side?
My
It's a
opinion
side
is
yard
no,
variance. I know, but that
Yeah.
doesn't say that, does it?
it doesn't specifically state it that way, right? That's a discussion over a beer.
Any other thoughts, comments, questions, changes,
What's the next step?
feelings? The next step would be Michael creates a clean copy, and then we can put it to a vote next meeting to adopt it as the policy. And put it on the website, and all the other fun materials that we give to people to help them. True?
Okay.
Okay. All right, and then with that, I believe that is the last agenda item. So, so the next meeting will be on June 2nd?
June 2.
Yes.
June 2nd. And as of today, we have just one matter scheduled, the potential.
Potential, if I can get it
That's right.
by Friday.
Right, and any other applications that get submitted for them as well. Okay. Just, are we doing any absences for June 2nd? Anyone exclusively here? No, okay. All right, with that, I'll entertain a motion.
I will, make a motion that we adjourn the meeting at 8:32.
Second.
The motion with a second, any discussion? Hearing none, all in favor?
Aye.
Hearing adjourned. Thank you very much. We'll see you all next one.